The Alberta Sovereignty Act is a very spicy law. You can think of it like a firewall. Maybe not a literal one, but it's a way for Alberta to push back against federal laws that it decides are unconstitutional by saying, well, maybe if you guys in Ottawa want to pass laws that overreach your jurisdiction, well, then maybe we don't have to enforce those laws. Can they do that? Can they pass a law that says they don't have to follow the law? This is the big question. After Alberta's government tabled a resolution stating that it is unconstitutional for the federal government to put restrictions on Alberta energy emissions.
We developed this legislation to shield the province from federal intrusions, and we're using it now because the consequences of this particular overreach would be so severe.
Danielle Smith really resents the idea of Ottawa putting caps on Alberta natural gas or coal plants. So accordingly, they say, Alberta shouldn't enforce those proposed caps and just shouldn't cooperate at all to implement them. Even if the federal government says, hey, what are you doing? This is the law. Let's try to tackle this question. Can you pass a law allowing you to disobey a law, starting with what the Alberta Sovereignty Act actually says?
I think it's a good piece of legislation, and what it really does is it underscores the way our country was always meant to work.
So this latest resolution taps into the power granted by the Alberta Sovereignty Act, and that act gives the Alberta government more power. On page 7, under the heading Powers of the Lieutenant Governor in Council, this law gives it brand new power to issue directives to a provincial entity and its members in specific situations. So they can tell provincial entities what to do. What is a provincial entity, you might ask? Well, they spend almost a whole page defining that. It could be a public agency, a crown corporation, a regional health authority, post-secondary school, police, basically any provincially regulated body. What kinds of directives could it issue? Well, whatever cabinet tells it to.
Now, Alberta says once such a motion is passed, then the cabinet will have the power to direct provincial entities within the province to do certain things or not to do certain things in order to make it difficult for that federal law to operate.
That's Eric Adams, by the way. He studies constitutional law in Alberta, and he knows a lot about this sort of stuff. So, the Act itself doesn't explicitly say public agencies are allowed to break federal laws, except it almost does. It says nothing in this Act is to be construed as authorizing any directive to a person that would compel the person to act in violation of any federal law. So they're saying, we're not telling anyone to disobey the law of the land. But then, look at the exception, other than a provincial entity. That's a pretty big exclusion that would seem to allow some public agencies to effectively pretend the federal law doesn't exist.
So one possibility is that the government simply orders municipal police, say, not to charge anyone or any electricity company with violating these federal regulations.
And Alberta is willing to go this far, to order its authorities to impede federal laws, because the proposed federal law that we're actually talking about here, they see as incredibly damaging.
It's been always popular in Alberta to go against the feds. Bush, criticized the feds as overly green.
We're going to ensure that all new vehicle sales are zero-emission vehicles and that we have a net zero grid by 2035.
So this all goes back to the federal government's plan for that second thing that you heard there, a net zero power grid by 2035. It's not law yet, but the intention is that overall emissions in Canada from generating electricity be completely offset, net zero, in the next 12 years, maybe by cutting back on energy production or switching to cleaner sources of power. The Alberta government has spent millions of dollars on ads trying to convince Albertans this would hurt their province badly.
aggressive emissions target would cause us to have to reduce our production by 1.5 million barrels per day. And that is, quite frankly, outside the mandate of the federal government.
Here's what she's talking about. According to Canada's energy regulator, some provinces will have little problem reaching the goal of hitting net zero by 2035 because they're already well on their way. Look at PEI. 99% of their electricity comes from wind. Newfoundland and Labrador, 96% hydro. Quebec is pretty close to that too. And most of Ontario's power grid is zero carbon, 59% nuclear with a mix of hydro, wind, and solar. But about 89% of Alberta's electricity is produced from fossil fuels, mostly from natural gas and about 36% from coal. According to the operator of Alberta's power grid, trying to hit net zero by 2035 would mean insufficient power, brownouts, and higher electricity rates, thanks to about $118 billion in higher energy costs.
They do not have a mandate to determine the pace and development of our resources or how we structure our power grid.
Danielle Smith says that's not achievable. Not only is it not achievable, but imposing these rules would lead to blackouts when it's minus 30 in the winter, say, and when there's not enough wind or solar power generated by Alberta's considerable wind and solar farms to fuel it without having some kind of fossil fuel burning generation.
On her weekly radio program, the Premier spoke specifically about why she says the federal government's clean electricity regulations are fundamentally illegal.
They have to stay in their lane. Their lane is clearly not electricity. Electricity, if anyone wants to read the Constitution under Section 92, falls to the provinces.
And yes, we can see Section 92 of Canada's Constitution. In each province, the legislature may exclusively make laws in relation to the generation and production of electrical energy. The federal government's plan to get to net zero by 2035 is just that, a plan with no legal force today. We are expecting to see a final draft next year, so it can still change. But it would mean putting clear limits on when and how Alberta's natural gas plants can operate, even if it doesn't ban their use outright. So if Alberta thinks that's illegal, can they just make a law that says they can ignore the rules? What's really interesting about what Alberta is doing here is that they're not explicitly trying to override federal law. They're just telling their own public agencies to ignore it. So in a way, sure, the province gets to tell provincial agents what to do.
It may be the case that a court says, yeah, to the extent that you're simply directing your own universities and towns and police forces to how to operate, then of course that is jurisdiction that the province has.
But that's just their side of the coin. The opposing argument is that, okay, you can try to make disobedience legal in Alberta, but Alberta is still part of Canada.
What the federal government may say in response to that is, well, you're not directing your provincial entities about provincial things. You are directing them in relation to federal matters. And that's where that act then becomes an unconstitutional interference in federal jurisdictions. Because if Alberta can do it, then every province can do it. And we may not have much of a country left if there's a button that any province can push to simply stop federal laws from operating within their borders.
So here's the bottom line. The constitutionality of Alberta's Sovereignty Act is still an open question. But for that matter, the constitutionality of whatever framework the federal government puts forward that might tell Alberta how to manage its power grid, also still an open question. So it's entirely possible this legal wrangling, this preemptive, we're not going to enforce federal laws before they're even enacted as federal laws?
It clearly is a symbolic gesture by the Alberta government to change the relationship with the federal government, to introduce a new, more aggressive form of federal-provincial relations, and whether or not it's actually articulating a new and viable way that provinces might realistically combat or push back against federal legislation. All of that remains to be seen.
So this is very much a stay tuned type of story, both legally and politically.